Hello, everyone, and thank you for joining me and my partner, Drew Broaddus, in this month's My PIP Monthly for July of 2019. My name is Javon David, and I'm a partner at Secrest Wardle's Troy location. This month, we'll talk about two cases that came down from the Court of Appeals, Slocum versus Farm Bureau and Duker versus Everest National Insurance Company. Thereafter, my partner, Drew Broaddus, will discuss a trending topic in PIP litigation. Specifically, he will talk about the Dye case that came down, which overruled Barnes versus Farmers Insurance. And again, that's Dye versus Esurance. He'll provide a comprehensive overview of what Dye versus Esurance holds and how it specifically affects claims handling, as well as your currently litigated cases involving coverage disputes. Now, the first case on our agenda for the case law update is Slocum versus Farm Bureau. That case involved a fatal motor vehicle accident and the court's decision as to whether or not children of the decedent receive full financial support or if they have to merely have their finances maintained after the death of a parent or someone they depend on for financial support that qualifies them for coverage. So in Slocum versus Farm Bureau, the Court of Appeals held that the survivor's loss provision of the No Fault Act is designed to maintain the support of an insured's dependents received before a fatal accident. The lawsuit arose from a motorcycle accident in which the plaintiff died thereafter. At the time of the accident, Robert Slocum was married to Rachel Slocum, and they had 3 children together. The children depended on Robert for financial support, medical insurance, and dental insurance. Farm Bureau General Insurance Company and the USAA insured the vehicles involved in the accident. Following the accident, plaintiff submitted a claim for two defendants for no-fault survivor's benefits for herself and her 3 children. Plaintiff indicated that all 3 children were living with her at the time and submitted documentation supporting her request for Robert's monthly after-tax income of $2,097. The plaintiff also included loss of fringe benefits, including medical expenses and dental insurance. Defendants did not immediately pay any of the benefits requested, which thereafter resulted in a lawsuit. Throughout the course of litigation, the parties disputed what was owed to the decedent's family member, specifically the children. The trial court ultimately ruled that the insurers were liable for the replacement cost of the dependent's medical and dental insurance and not just the premiums paid by the employer. The parties moved for reconsideration and appealed of the trial court's orders and appealed the denial of those motions. On appeal, defendants argued the dependents were only entitled to the amount Robert's employer contributed to the dental and medical policies and not the replacement cost of those policies. The court upheld the trial court's determination that the dependents were entitled to the economic value of the medical and dental insurance, not the premiums paid by Robert's employer. The court opined the main question in a survivor's loss claim is what the dependents would receive if the deceased had not died. The goal of this particular no-fault provision is to maintain the level of support the dependents received and not just the finances sustaining the support. In holding this way, the courts analyzed the legislative intent of this particular provision of the No Fault Act and found that the legislature specifically chose to provide compensation for contribution of tangible things of economic value that dependents would have received for support during their dependency. The court thereafter explained that the legislature would have stated if they intended to continue only the previous financial payments rather than the resulting things that were contributed. So, in other words, the legislature would have said that a carrier is only responsible for premiums paid rather than the replacement cost of those things. It would have explicitly been clear in the statute that they had determined one thing versus the other. So ultimately, the court ruled that the purpose of survivor's loss benefits is to continue the level of support the survivor received from the decedent and not merely maintain the finances of the support. So in this particular case, when addressing the issue of medical and dental insurance, the dependents were entitled to the replacement cost of new medical and dental coverage they received prior to the decedent's death, rather than the monetary value of their premiums. So this is important when you're dealing with a claim that has a decedent and children left behind or a spouse left behind, and you're trying to determine whether or not you owe for parts of the claim. While I would anticipate that, going forward, individuals and claimants or their attorneys will rely on the text of the statute itself, but also this case to support their position that the purpose of survivors' loss benefits is to continue the level of support that they once received. And that includes things like the dental insurance and like the medical coverage, rather than just the value of those prior premiums. The next case that came down this month that we think is relevant for claim handling and to discuss on this podcast is Duker versus Everest National Insurance Company. That case involves an alleged material misrepresentation and how the interplay between an insurance agent and a claimant responsible for signing and reviewing all the papers submitted to a carrier can come into play in the course of a claim. In this particular case, the plaintiff was seriously injured in a motor vehicle accident and filed a first-party claim with Everest under her insurance policy. During the application process, the plaintiff was assisted by an independent insurance agent. On the first page of the application for insurance was a paragraph containing the following statement, and this is pretty typical in a lot of insurance policies. The statement said, all household members age 14 or older, including but not limited to spouses, roommates, children, family members, and wards, must be listed as potential drivers. This paragraph was entitled the Driver Information Note, and there was thereafter a line for the signature block of the individual signing the application. Finally, at the end of the application, above the signature line, was a paragraph entitled Applicant's Statement, read before signing, and within that paragraph was the following statement. I certify that all household members age 14 or older, including but not limited to the spouse, roommate, children, family members, and wards of the undersigned are listed as potential drivers. The plaintiff signed the statement and submitted her application for insurance to Everest Insurance Company. Everest thereafter issued a premium, but unbeknownst to Everest, the plaintiff had two sons living in her household that were both over the age of 14. Throughout the course of the claim, Everest discovered that she had these two sons over the age of 14 living in her home. Everest filed a motion for summary disposition, arguing that plaintiff made a material misrepresentation on the application that voided the policy and warranted rescission. Everest further argued that had plaintiff disclosed her two sons, her premium would have nearly doubled, and therefore rescission was warranted. Plaintiff argued that it was largely the insurance agent who completed the application and that the insurance application was ambiguous. Ultimately, the trial court granted defendant's motion for summary disposition and found that plaintiff's misrepresentation warranted rescission of the contract rather than reformation of the contract. On appeal, plaintiff argued that the trial court erred by granting summary disposition, and the Court of Appeals ultimately upheld the rescission of the policy. Plaintiff argued that reformation was the appropriate remedy rather than rescission because her material misrepresentation was made innocently as she was guided through the application process by an independent insurance agent. The court did not buy plaintiff's argument, noting that plaintiff ultimately provided the information to her agent, signed the application, and certified that she had disclosed any household members above the age of 14. In support of its decision, the Court of Appeals reviewed longstanding case law and noted that it is not a defense that the insurance agent completed the application and that plaintiff did not read the application, citing the case of Montgomery versus Fidelity, which is a 2005 published Court of Appeals decision. In addition, the court relied on case law from Lash versus Allstate, a 1995 Court of Appeals published decision, which stated that rescission of the policy is the appropriate remedy for a material misrepresentation made in an application for no-fault insurance. Now, this is key because oftentimes when you're working to investigate a claim or if you're litigating a file with your counsel, you often hear the defense that I didn't sign the application or I didn't fill out the application, I signed it, but my insurance agent completed all the information. People will often try to punt the misrepresentation over to the insurance agent. Well, this case law, in addition to Montgomery versus Fidelity, is going to be key when you're responding to those kinds of arguments. You're going to say, even if your agent submitted the application on your behalf, you were responsible for reviewing it and for signing with knowledge of what the application contained. And this, you can note your file and the claim notes that you explained all of this to a claimant, and you can work with your counsel if this kind of argument arises, which I personally often do see in the course of litigation. So those are the two main cases we wanted to discuss this month. We'll next talk about the trending topics in PIP litigation. I'm sure you are all eager to hear about Dye versus Esurance, which is a very significant case that overrules Barnes versus Farmers Insurance. Now I'll turn this over to my partner, Drew Broaddus, who will take the lead on discussing Dye versus Esurance.
Thanks, Javon. We're here to dissect Dye versus Esurance. We have it under our trending topic, so this could also be a case law update, but we're putting it here because it affects a lot of pending cases. It also affects claims handling, and we can probably expect to hear more about this decision as the plaintiff's bar tries to push the holding probably beyond what it actually says. So we'll be hearing more about it, I'm sure. I argued Dye in the trial court, the Court of Appeals, and the Supreme Court. Although the first defendant on the caption is Esurance, I represented Geico, which was the main defendant. Because of the mystery of the priority scheme, Geico was in a situation where if the Esurance policy satisfied 500.31011, then Geico would be first in priority. But if the Esurance policy didn't satisfy the statute, then Matthew Dye was kicked out of the PIP scheme entirely and no one had to pay his bills, in the no-fault system at least. So to explain Dye, we first need to explain Barnes versus Farmers, which is published Court of Appeals decision from 2014. The Barnes case involved a 2004 Cavalier. The sole owners of that vehicle were mother and daughter. At some point, they fell on hard times, couldn't afford to insure it anymore. The opinion mentions that they really didn't drive it a whole lot, kind of just a back and forth to church on Sunday sort of thing. So they let the insurance lapse. The mother had a family friend who did not reside in the household insure it for her. There was testimony that she paid him back for it, but so this individual took out a policy from Farm Bureau covering the Cavalier. He's the only named insured on that vehicle. So the daughter is hurt driving that vehicle. State Farm denies the claim, presumably because it's not her insurer and it doesn't insure anyone in the household. Again, the only policy State Farm wrote was to this friend of the family who didn't live with them. So State Farm files a motion. The trial court determines that the friend who bought the policy, again, the only named insured, had no ownership interest in the vehicle. Farmers gets the case from assigned claims, plaintiff being uninsured at that point, effectively. Farmers makes the argument that because, per the statutory language we'll talk about later, the daughter is effectively uninsured under the statute. Court of Appeals accepts this argument, writes a very short, barely 4-page, unpublished opinion. The fact that it's unpublished is kind of significant, kind of ties in later to the Supreme Court's review of this. When the Court of Appeals doesn't publish an opinion, basically they're just resolving the dispute between those parties. They're not writing something that's expected to be precedent down the road. It's not something that they have to follow. It's not something they're expecting other courts to follow. They're just resolving a particular dispute. So sometimes those are a little short on facts and reasoning. In this case, again, being an unpublished case, didn't say a whole lot about how they reached this conclusion. But 4 months later, the Court of Appeals redesignates it for publication. Doesn't make any substantive changes to the opinion, which is normal when this happens. What's not normal is the redesignation. It's very rare. Everyone that wins their case in the Court of Appeals wants it to be published because they want to be able to cite it down the road. So these motions are fairly common, but they're not very commonly granted. In Barnes it was, so it became precedent. Plaintiff doesn't seek Supreme Court review. So Barnes dealt with a very specific question of statutory construction as applied to a very specific fact pattern. A person being injured in a vehicle that they own and that no owner or registrant has insured. It was a pretty unpopular opinion from the start. In my experience, both plaintiff's counsel and many trial court judges just couldn't accept the result that a vehicle could be insured under a policy, but the statute still not be satisfied because the only named insured was a non-owner. Many had interpreted a 2008 published Court of Appeals opinion called Iqbal versus Bristol West as holding something else. That had been interpreted for a long time to say that basically any coverage on the vehicle will do. The Barnes panel distinguished Iqbal on the basis of facts that it's questionable whether the Iqbal panel really placed a whole lot of emphasis on them, but the Barnes panel got around Iqbal specifically because in Iqbal, the facts were two brothers shared a vehicle. One brother insures it, puts his name on the policy. He's the only named insured. The other brother doesn't take out any coverage, and he's not on the brother's policy. The brother that didn't buy insurance predictably gets hurt in that vehicle. Bristol West makes an argument about the fact that he's not on the policy, and what we end up with is a holding from the Court of Appeals that says the other brother's policy is okay because he was a co-owner and because every single owner doesn't need to insure a vehicle. They specifically went out of the way to say every owner doesn't need to insure it. So what the Barnes panel picked up on is, well, by implication, some owner has to insure it. So here's where we get to Dye. The facts: Matthew Dye buys a 1997 BMW. He is busy. He just got married. He was in the service. He'd been overseas for a while. But he's home, but he's busy. So he asked his dad to take out a policy on this new car that he just got. The dad, Paul Dye, lives in a different household, buys a policy from Esurance, but only names himself as a named insured. So the vehicle's covered, similar to Iqbal, but the only person on that policy is the dad. And a few days later, again, they own this vehicle for a very short time. It's just one of the many odd facts about this case. Matt is injured while driving the 1997 BMW. His wife is insured by Geico for other vehicles, but not the BMW. Initially, he sues Esurance. Geico is later determined to be first in priority as the household insurer. Barnes is released in the middle of this litigation, and so Geico argues that it's controlling. The trial court gets around Barnes by holding that Paul was a constructive owner of the 1997 BMW as a matter of law, which makes the Esurance policy okay, because the argument being under Barnes, at least one insurer has to insure the vehicle. So Geico appeals, Court of Appeals, bound by the Barnes panel's earlier interpretation of the statute, because it's published, it became binding precedent on everybody except the Supreme Court. Court of Appeals says the constructive ownership could not be decided as a matter of law and had to be decided by a jury. So the implication is if the jury decided that the father didn't have an ownership interest, Matt would be kicked out. Same result as the plaintiff in Barnes. Before that trial proceeding ever happened, Dye appealed to the Michigan Supreme Court, arguing that Barnes was wrongly decided and therefore none of these remand proceedings were relevant, because the only reason the ownership interest was relevant is if Barnes was correct. There's a very weird backstory. I don't know how important it is other than just to emphasize the weirdness of all of this. Neither the plaintiff or Geico sought the Supreme Court's review for the first 41 days. You have 42 days to ask the Supreme Court review. On the 42nd day, Esurance files a leave application on an unrelated issue with a dispute between it and Geico. That opens the door for the plaintiff then to file cross appeal. They get 21 more days. They decide, geez, if this is going to the Supreme Court, we may as well try to get something out of it. So they ask for leave on the question of Barnes. For what it's worth, we also filed a cross appeal from the cross appeal saying that the Court of Appeals shouldn't have remanded and that all of this could be decided in our favor as a matter of law. When the dust settles, Esurance's application is denied, our application is denied, and the plaintiff's is granted. So the Supreme Court is going to squarely decide the issue of whether Barnes was correctly decided. And all of this is really based on not the case law, but statute. MCL 500.3113, subpart B states, and I'm going to paraphrase, person is not entitled to be paid PIP benefits for injuries if, at the time of the accident, the person was the owner or registrant of a motor vehicle involved in the accident with respect to which the security required by Section 3101 was not in effect. And if you're looking at the slide, the ellipses took out the language referring to motorcycles. Same rule applies to motorcycle. Got to insure your own motorcycle. So 3101, subpart 1, in turn, states that the owner or registrant of a motor vehicle required to be registered in this state shall maintain security for payment of benefits under PIP and personal protection insurance as required by this chapter. So this sets up Dye. These are the two provisions that are before the Supreme Court. And the Supreme Court concludes, this is my takeaway from, I think, a 10 or 12 page majority opinion. An owner or registrant of a motor vehicle involved in an accident is not excluded from receiving no-fault benefits when someone other than that owner or registrant purchased no-fault insurance for that vehicle, because the owner or registrant of the vehicle may maintain the insurance coverage required under the No-Fault Act, even if you did not purchase the insurance.
So what is exactly meant by maintain under this holding?
Well, that's a loaded question. That was at the center of the oral arguments and really at the center of the opinion. Our position, and if you take a look at Justice Clement's dissent, she probably said it better than I did, but to maintain requires you to put yourself on a policy, to be the named insured on some policy, because, and we laid this out in the briefs with the definition of the word maintain, it requires some active, as opposed to just passive letting someone else handle it, which was the argument I kind of made as Matthew and some of the people in the other cases where the similar fact patterns, they're just sort of, somebody will handle it. And they're not actively going out and buying a policy. So that was our position. The only objective way from the insurance industry's perspective that we can know someone's maintaining coverage is if they put themselves as the named insured on a policy. Not an additional driver, named insured.
Not just having someone else get you insurance and you're paying them.
Right? Yeah. And that was the fact pattern of Barnes, which we made some fuss about. Now Barnes is obviously gone, but there was testimony there that the owner had paid for the policy. She just, for whatever reason, didn't go out and buy it or put her name on it. So again, to really, our position in a nutshell is really summed up well in Justice Clement's dissent. If anyone is looking at this opinion, it's on the Court of Appeals website, Supreme Court website. It's a number of places online. So the 5-justice majority, Justice Clement dissented. Justice Kavanaugh didn't participate because she had just joined the court. It wasn't that oral argument, and they didn't need her vote because it was 5-1. They concluded that the Court of Appeals got it wrong in Barnes. And based on the plain language of 3101 and 3113B, with a little help from some dictionaries and other parts of the Act, they found that an owner or registrant of a vehicle is not required to personally purchase the no-fault insurance. So that's getting at what our specific argument in the case. So they're specifically addressing that and saying you don't have to personally buy it for your vehicle in order to avoid the statutory bar. So then they went on, rather, the 3101, subpart 1 only requires the owner or registrant to maintain no-fault insurance, and the term maintain means to keep in an existing state. So they would not read into the statute what they consider to be reading it in. We think it was implicit by the language that's there, but they wouldn't read in a requirement that they purchase or obtain it themselves. So that's DIE in a nutshell.
It effectively, just so for our listeners, Barnes is overruled, and this will now be the controlling law going forward with these kinds of claims.
Right.
Okay.
And there's nowhere else to appeal it.
Yeah. And we decided to feature this particular case in our segment of trending topics in PIP litigation because we've all gotten several questions on how to navigate claims and cases going forward in light of this new decision. Oftentimes, you're thinking about Barnes and when you get these types of fact patterns we've discussed, but now you've got to change your framework and be sure you're working with your counsel to understand how the new case law applies and how it affects your claims going forward. So Drew and I talked about the common questions that we received, so he'll kind of go through and answer those for you. And of course, if you have any more questions, you can always reach out to someone at Secrest Wardle. Drew is the attorney that knows this in and out. He was there at the ground level. So he'll be able to answer your questions pretty thoroughly.
So the easiest way to answer any questions about DIE is to get back to the facts of DIE and keep in mind what that case was actually about. In DIE, the insurance policy that was purchased by Matthew's father for Matthew's 1997 BMW satisfied the Act, regardless of whether the father had any ownership interest in the vehicle. The court said it's sufficient for any person to provide the required insurance, and all that matters is that the vehicle is insured. So Barnes and the other case laws expressly overruled. When they reference other case law, there was a few unpublished cases that had followed Barnes. Not particularly important for this discussion. Big takeaway there, Barnes is no longer good law. Although the opinion does not expressly deal with retroactivity, we're expecting it to apply to all pending cases. The big thing here, some of you probably remember Covenant with the provider standing. there was no decision of the Supreme Court that was overruled. The Supreme Court simply overruled a line of Court of Appeals cases, which makes the argument for retroactivity even stronger. The theory being the statute never changed; it was just misinterpreted. The Court of Appeals opinion in W.A. Foote, which is a covenant decision where the retroactivity of covenant was dealt with, talks about this in some detail. W.A. Foote is being reviewed by the Supreme Court right now, so the retroactivity question, to some extent, is still open, but my assumption is it's going to apply to everything that's in the courts right now.
That's everything that's pending.
Everything that's pending and everything going forward.
All right.
And it's also important to emphasize what DIE is not about, because I've gotten some odd questions and some people have looked at this opinion and taken away something that maybe isn't there or maybe could be there if you look closely at it long enough. I don't know. But it's important to realize in DIE, there was never an argument about insurable interests. The Geico position was never that that the insurance policy was void because of the father's lack of insurable interest. That would have been an interesting argument. It's a hard argument to make. There's a Court of Appeals decision called Morrison from, I think, 2006 that talks about insurable interests. They're broader than ownership interests. So it's tough to negate the existence of an insurable interest. It can be done. But that wasn't what DIE was about. So this is still an open question. Policy can still be void if the only named insured has no insurable interest in the vehicle. Has nothing to do with rescission or the Bozzi versus Sentinel saga, where the Supreme Court just recently decided that you can rescind a policy for fraud in the application. Again, these are facts that closely mirror some of the rescission cases, either that are on the books or that will come up in the future. There's a viable argument that that Matthew Dye's father misrepresented the fact that he owned the vehicle when he took out the insurance policy. We don't know for sure. I don't know that the application is in the record. It wasn't an issue in the case, in part because the Bozzi case law was still working its way through the courts, and also that would have been insurance's argument to make. So the short of it is that was never argued. Dye doesn't deal with Bozzi. Bozzi doesn't deal with Dye. They're separate issues. Also, the statutory changes that went into effect June 11th, 2019 don't deal with this. The majority and Justice Clement's dissent both specifically say this has nothing to do with the statute. I don't think there's anything in the statute that would change this result in a future case. I know Javon's a little bit more familiar with the statute.
I agree with you. There was nothing with this particular provision that was changed or amended. So it would really just be looking at this particular case when you have the kinds of claims that are applicable. You wouldn't have to go back and make sure that it's any statutory language was changed or anything like that. No.
And it does not open the door for plaintiffs to reopen suits that were dismissed under Barnes. I got a question about that. It's an interesting question. I had to think about it for a minute. But the only way those suits are going to come back is if they had an appeal pending. If they had kept that in the pipeline until the point that Dye came out last month, then they would come back. But if the case was done and over with, if they accepted the summary disposition, didn't argue, or didn't appeal, or the appeal's over, those cases are gone forever.
Okay.
And Dye does not say that it's okay to be uninsured. I think it's only a matter of time before some plaintiff's counsel cites that case for the proposition that you're not kicked out of PIP for driving an uninsured vehicle that you own. Because at a very simplistic level, that could sum up the Dye case, but that's not what it held. That's not what the statute says. Somebody still has to insure the vehicle. It just doesn't have to be an owner anymore. I'm told that this was the way claim handlers approached it for a long time before Barnes came out in 2014. Most people construed Iqbal to say this, that any insurance will do. So we're kind of back to where we were before Barnes. In that regard, this isn't really a new holding in a sense. It's just restoring what I think a lot of people understood the rule to be 5 years ago. So the way this sort of thing's dealt with, I think on the front end, when they apply for a policy, again, there are going to be rescission scenarios if someone's taking out a policy only naming themselves and they don't own the vehicle. We got to look closely at the insurable interest requirement, and that's how it's going to have to be going forward.
All right. Again, if you have any questions, you're welcome to submit them to us, and we appreciate you listening to My PIP Monthly this month, and we hope to see you next time.